Hello everyone, I'm Sanidhi. My teammates are Vinith, Vinay, Basuraj, Abhinandan. Today we'll be presenting about Memorandum of Association and Articles of Association linking with the subjects legal aspects of business. MOA and AOA. The Memorandum of Association, often just called the Memorandum, is a foundational document for any company defined under Section 256 of the Companies Act 2013. The memorandum outlines the scope of a company's activities and powers. Think of it as the company's constitution. It sets out the company's objectives, the range of the activities it can engage in, and serves as a public document that informs shareholders, creditors, and other about the company's fundamental aspects. Moving on to the Articles of Association under the Companies Act 2013, Section 2 of 5 covers the definition of Articles of Association according to the uh, four set of section AOA or articles contains all the rules and regulation formed by the directors of the company to govern the internal management and governance, which also be altered from time to time. In a nutshell, I mentioned earlier, it is the rule book that recognizes inner workings of the company while binding the company to its workers and vice versa.
My name is Vinit Kemari, and I am going to tell about key differences of MOA and AOA. So, MOA is a fundamental document that defines a company's relationship with the outside world. It includes details like company's name, registered office, objectives, members' liabilities, and capital structure. The MOA defines the external scope of the company's operations. Then, what is AOA? AOA, on the other hand, contains the internal rules and regulations for managing the company. It covers matters like conducting meeting, appointment of directors, share transfers, and dividend declaration. The AO governs the internal management and daily procedures of the company. And in description of MOA, a constitutional document that defines the company's relationship with the outside world. And the description of Article of Association is a document that contains the rules and regulations from the internal management of the company. Next is components. The component of Memorandum of Association is name of the company, registered office, objective of the company, liability of member, capital clause, etc. And the component of Article of Association is rules for conducting meetings, appointment of directors, transfer of shares, decline declaration, etc. And next is last, the scope of activity of MOA is defines the external scope of company, and AOA scope of activities governs the internal and procedures of the company.
Remember, I am Abhinandan. Today I am going to explain the remaining key differences of Memorandum of Association and Articles of Association. First one, filing at the time of registration. Memorandum of Association is mandatory at the time of company's incorporation. It must be filed to legally establish the company's existence. The Articles of association is not mandatory for all companies, particularly under certain jurisdictions. However, it is highly recommended for private companies to govern internal procedures and management practices. Significance and positions. The Memorandum of Association holds the position of being the supreme legal document of the company. It defines the company's objectives, powers, and scope of operations in relation to external parties. The Article of Association is subordinate to a Memorandum of Association. It outlines the internal governance duties, rights, and responsibilities of members and directors, but not extend beyond or contradict the Memorandum of Association. The last one, connections between both. The Memorandum of Association overrides the Articles of Association, meaning that if any conflict arises between the two documents, the provisions of Memorandum of Association will prevail. The Article of Association cannot override the Memorandum of Association, ensuring that companies' internal rules remaining consistent with its legally established objectives and powers.
Hi, sir. I'm Vinay Kumar. I am going to presenting legal effects of MOA and AOA. The MOA and AOA are crucial documents that legally the member of the company together they from framework that governs a company external internal relationship. According to Companies Act 2013, this document not only define company purpose of the power but regulate internal administration. First, the MOA and AOA creating contact among the company's member. Every member company legally terms condition started with this document. Importantly, individually member does not process the right independently enforce article against another member. If a company acting corporate entity that must bring legal action be of member. When it come outside this who are not member of the company, MOA and AOA do not create controversial right. Even if an outsider name approve this document, this does not enforce any rights against the company. Next, member of bonding the company. They must act within the limits set by the MOA and AOA. The company is bound to its member. It must also respect and enforce right outline this document. Member are bond each other through the company, but they cannot such each other individually. They must act through corporate entity.
Mr. Sir, I am Basuraj here. I will explain about the doctrine of ultravirus. Doctrine of ultravirus is anything done by the company behind the power confirmed by the Memorandum of Association shall be a ultravirus to the company. These types of acts are wide and cannot be rectified even by the share, even by all the shareholders. Example, like suppose a company is registered for the textile business as a memorandum of association, but it tries to start a restaurant business. This act is ultra-virus and invalid. Next one is doctrine in Indo management. This the doctrine is a favor of outsider and against the company. It means outsider dealing with the company are not required to ensure that internal company procedures were properly followed. Outsider can assume that everything inside the company is regular and proper. Example, if the manager signs a contract, an outsider can trust the manager as the authority. They did not have to check company meeting minutes or approvals. Thank you.